Court Survival Guide. Important notices. 1. This survival guide is offered as educational material only, and is by no means complete nor all-inclusive. There is a wealth of information here which can be applied to any case where a government agency is bringing a criminal action against a citizen, such as traffic and IRS cases. The information in total may or may not apply to you. And there will always be more details and knowledge which applies to your case, and you are obliged to collect as much information as there exists for your purposes, from all sources. There are just too many parameters in the legal process to adequately cover all possible scenarios for a given situation in one manual. Hence, this guide is general at best, and cannot be expected or be held to suffice as legal advice at the level expected from licensed attorneys. The main advantage here, however, is that the guide tends to illuminate much of what the judges and attorneys do not want you to know. You can cut right to the chase, if you want, and eliminate considerable time and confusion to win your case. 2. If you have successfully followed the guidelines in the Vehicle Survival Kit and/or the Citation Refusal Kit, you may not need a Court Survival Kit, by virtue of not having to appear in court on some phony traffic charge. 3. There is a lot to this guide, because each case is different. However, you may focus on the easy and quick method which requires only one court appearance. The rest of the guide covers other cases that have somehow slipped through the cracks. 4. We get a lot of calls from people who first get themselves into a traffic court, and then decide to find out about sovereignty, i.e. the cart before the horse. So we have published this guide to offer help with these cases as well. 5. The fact that you have obtained this guide suggests that something has gone awry in your path of sovereignty. Either you have not been able or allowed to follow the procedures which keep you out of court, such as found in the Vehicle Survival Kit (VSK) or the Citation Refusal Kit (CREEK), or someone you know has managed to get into a jam before establishing your sovereignty. This guide addresses cases such as these, to help empower the people who are coming from an obviously disadvantaged legal position, as there is no completely foolproof technique to always beat the system. So here we are attempting to improve the odds considerably. 6. The purpose of the Court Survival Kit is to help you effectively handle any court confrontation in which you risk losing more of your rights, money, freedom, and/or property. It is assumed that you are somehow obliged to appear in court for something, and you want to protect whatever rights you have left. This guide contains techniques that can help in any traffic case, tax IRS case, or any case brought against you by a government agency. 7. Although much of the information herein may also help in cases where you are the plaintiff prosecutor who has filed a common law suit against a public official, this guide is instead written from the perspective of defending yourself against a prosecutor who is going after you, because of charges that you know are inherently fraudulent. 8. If you really want to minimize your total risk, and be done with your case ASAP, then you might consider just acting sorry and poor, and plead guilty to the charges. This is what the court expects, and this is what it is designed for. The only problem is that you will be obliged to reintegrate yourself back into the oppressive system of traffic slave laws that put you in court to begin with. You will be expected or perhaps even ordered to abide by the rules of the system. You will lose the game by not standing up for your rights, but you will have minimized your immediate cost, financial and emotional. So, in this guide, we assume that you want to win your case. If you haven't much to lose, then you have an advantage over the court, which has much more to lose than you do. 9. Keep your court survival guide in a safe place where you can easily get to it when you need it. Maintaining a complete kit is vital for showing up in court as fully prepared as you can possibly be. This survival guide is intentionally written as briefly as possible so that you can easily access and use it. Knowledge of the truth is a great tool here, but the more skillfully you can apply it in court, the more empowered you will be, in any case that challenges your freedom. Remember, this is a situation in which the knowledge alone is not enough. You must also be able to perceive things as they are happening, and to think on your feet, so that you will instantly know what options are yours to use, when you have the opportunity. 10. Most important. Mere knowledge of these techniques and truths will not be enough. Just by mentioning such things in court will not, of itself, help you win your case. A piece of paper is not by itself an automatic shield. You cannot depend on the court to police and correct itself. It is up to us, we the people, to detect and demand correction to the court's errors and fraud. You must be able to think on your feet and stay on top of each argument as it comes down, so that you can logically steer the judge into a corner. You will be going head to head with judges who are very slippery, or who may be ignorant as to the real law, and how fraudulent their system of justice is. You will have to do your homework. Maintaining complete inventory. Your complete court survival kit consists of 0. The flag you provide, a small U.S. flag on a stand, but no gold fringe. This is your basic proof and exercise of your status and rights in court. You would bring it with you and set it on each table or bench where you stand, whenever you are going to directly challenge jurisdiction. 1. Your personal licensed court recorder, highly recommended. You must make sure that all of the court conversations are recorded without risk of being erased by the judge, so that the evidence which floats to the surface can never be denied. Bring your own rather than rely upon the court to preserve the truth. If this is not possible, make sure you bring people. 2. Legal counselors, not licensed attorneys. These are your personal helpers or counselors to sit behind you in the courtroom, to help you stay aware of and record what's happening and your options, while you are dealing with your emotions. More is better. 3. True copy or original paperwork. All legal documents or evidence you can find, which relate to your case status, tickets, receipts, depositions, invoices, notices, letters, warrants, names, dates, places, etc. 4. Copies of all relevant laws that apply to your case. Photocopies of the statutes, codes, laws, and constitutions, which back your position and defense. 5. Court Survival Guide, provided by FRP. Closing parenthesis. 6. Pen and paper. 7. Pocket tape recorder for your own protection and cost savings, to be concealed, and not to be used as admissible evidence. Use this as a backup for your own licensed court recorder. Representing yourself as a sovereign citizen. You should represent yourself always, in propria persona, in your own person, or pro per. This alone qualifies you as an attorney in fact, according to Black's Law Dictionary. By asserting your sovereign right to represent yourself in legal matters, you are establishing your status as your own attorney, without being misled, trapped, and overcharged by a licensed defense attorney, who would only bind you into the very system which is dedicated to making you pay. Do not hire a licensed attorney if you intend to keep your rights and your money. There is no law which requires anyone to hire an attorney. If anyone tries to intimidate you or deny your rights by asking you if you are an attorney, you can always reply, "In fact, I am." Bring your flag with you wherever you appear in court, to show your sovereignty. By representing yourself, you are free to expose any of the many fraudulent deceptions and procedures being used against you. The court can assign a public defender to you, if you want to just pay some money and get out. But remember, the public defender is just an officer of the court, trained to only reduce the fines in exchange for pleading guilty. If you do this, you will not be allowed to expose the corruption, you will lose your case and your money, and you will have a conviction record. So in order to effectively represent yourself and your interests, your mission is to proceed in propria persona, or pro per. This is what you must sign on every court document next to your name. This means that you are not only the legal counsel representing the defense, but you are also the accused whom you are representing, in person. Do not represent yourself any other way. This also means that the judge cannot lawfully hold you responsible for conducting yourself or your case, as a licensed attorney, nor can he/she force you to hire one. You are free to proceed as you see fit, as a sovereign citizen. Your legal counselors are just that, counselors. And there is no law preventing your friends from consulting with you during any court proceeding. Some judges and prosecutors will expect you to proceed pro se, another method of representing yourself. Do not let this happen, because pro se means that you are legally representing yourself as your own attorney, which the court can then pervert to mean that you can be told by the court how to proceed with your case, and the judge may try to impose the same standards upon you as are imposed on a licensed attorney. The court would be allowed to treat you, as your own attorney, differently than it would treat you, as the accused. So don't let this happen. You will know when to declare your pro per status. Using legal counselors. This is the single most helpful element of your survival in court. Some people have a natural ability as legal eagles, to know the laws and court procedures cold, and to argue law logic with the best of them, and eventually win their case. Such people are born fighters and can masterfully find their opponent's weak spots, and outwit them, many times by pure attrition. If you are one of this rare breed, you probably don't need any legal counselors with you in court. More power to you, and heaven help the lawyers that get in your way. However, most of us regular folks have made it a point not to get involved with the legal details, not to learn any court procedure, and to avoid anything to do with the legal system altogether. Let's face it, most of us have gladly left the boring and/or offensive drudgery to the lawyers, just to stay out of court. So, it makes a lot of sense to keep the company of legal counselors, and to have them around you in your time of need. It really pays to have extra opinions and to be made aware of options when you need them. The fact is, the courtroom environment is naturally oppressive, intimidating, and humbling at best. And most people are sensitive to such an environment, to the point of dealing with more emotions than they need at the moment. So the purpose of your counselors, who are worth their weight in gold, is to keep the logical thinking process going, and to keep you aware of your legal options, while you are conducting your defense immersed in your own emotions. Although your own judgment may become occasionally cloudy or confused, your counselors will be maintaining a much clearer understanding of the facts, the law, your rights, and they will be carefully watching the judge and prosecutor for signs and indicators. You will be able to pause the case at any time to confer with your counselors. The basic strategy in court appearances. We always try to use the best, most effective, and direct strategy up front at the first court appearance, so that the case is dismissed, i.e. we win and we never have to go back. So the balance of this court survival guide applies only to other cases that have slipped through the cracks. You guessed it, it's another game. No more, no less. Very much like poker. The stakes are essentially your freedom, money, and property versus the court's false authority and power over you, for lack of a better expression. Much of your power comes from invoking your common law rights. And since all have received sealed orders from the U.S. Attorney General to change over to Article 3 common law jurisdiction, you may soon not need to work so hard to retain your rights. Object of the game: to get out of the court system as soon as possible, by getting the case dismissed or thrown out, and the system is rife with glaring opportunities for doing so. The longer you stay in the court system, the longer you are at risk, and the more money you will lose. The judge's object is to convict you quickly and collect your money, while maintaining the illusion of authority and power over you. The prosecutor's object is to prove the conviction that you are guilty, at any cost, even lying, and make a psychological example of you to intimidate others. The players: you, the judge, the prosecutor, the jury if any, the officer, the other witnesses if any, and your counselors. The judge and the prosecutor are both experienced players, and extremely slippery. Neither can be trusted to tell the truth, and they will most assuredly give the impression that their words are absolute truth and law. In addition, you can depend on the prosecutor to be unfair, devious, fraudulent, and conniving in his/her efforts to win the game. Lawyers, in general, have absolutely no respect for the real law. They consider themselves smarter than the people, using their private exclusive membership in the bar. You have the right to represent yourself, pro per association, to manipulate court procedures, in order to steal money from others. Just look in the phone book and see the disproportionate number of people in this profession versus the other professions in your area. The playing field. You are in a rigged game. You are the visitor, and playing without the home field advantage. You can forget about truth and justice, as these have been eliminated. The only way you will win is by embarrassing the court. This is a cash register court, with absolutely no vested interest in proving your innocence. They just want your money, and your obedience to the rules which take your money. The deck is already stacked against you, just by your showing up and being there. You are already convicted and presumed to be guilty. You have already been treated as guilty by the arresting officer, and you have proven your guilt by signing the ticket. The judge and prosecutor are both playing together against you. They have both taken a secret oath to work as agents for the foreign banks, in their efforts to maintain control over you and your money. The game, as a minimum, will be interesting, challenging, and educational. Playing the game. There are many strategies, tricks, maneuvers, and legal points to argue about that are good to know. Currently, we would go for the best strategy at the first appearance, getting a quick dismissal, and avoid having to fall back on the rest of them, and how you play the game will affect how your opponents play, and vice versa. Since their jurisdiction over you is conveniently implied by your unspoken consent, it must be challenged right up front, so that you will be able to stand on the Constitution, and maximize your chances of early dismissal. Otherwise, very few of your other strategies will work well. Not all of the factors will come into play in every court appearance, especially in the initial stages of your case. Some of these rules apply to some hearings, and some will apply to others, as you will see, but here are some basics that you really should understand for any such appearance. 0. Rights which they will try to cheat you out of. These are some of your rights that are good things to know in general. The lower courts do not recognize most of them, since they are not common law courts. To argue most of the constitutional rights, you would need to appeal to a higher or district court. Depending on how far into your case you get, you may wish to address a few of these. You have the right to be informed of the nature and cause of the crime, 6th Amendment. You have the right to specifically reserve any or all of your rights. You have the right to remain silent, to stand mute, 5th Amendment. You have the right to say what you want and to be heard, 1st Amendment. You have the right to object to any statement by the judge and or prosecutor. You have the right to recluse, dismiss, the judge. You have the right to call witnesses to assist your defense, 6th Amendment. You have the right to have legal counsel for your defense, 6th Amendment. You have the right to conduct your defense, pro per, free from the professional restrictions imposed upon licensed attorneys. You have the right to submit motions. You have the right to a fair trial. You have the right to change your plea any time before trial. You have the right to appeal any judicial decision. You have the right to a speedy and fair trial by an impartial jury, 6th Amendment. You have the right to waive court and transcript costs, on the basis of pleading, in forma pauperis, no money. You have the right to due process of the law trial before you are deprived of any liberty, property, or money, 5th Amendment. You have the right to efface the injured party claiming damages, Article 3 and 6th Amendment. You have the right to face your accuser and witnesses against you, 6th Amendment. You have the right to inform the jury of the truth, their rights, and their duties, 1st and 6th Amendments. You have the right to put the judge on notice of your intent to preserve your rights. You have the right to put the judge on notice of your intent to appeal any ruling or decision during the case. You have the right to protest and object if any of your rights or demands are not being met. You have the right to demand that the court place in evidence any unrevealed contract, statute, law, rule, or information being used against you, 6th Amendment. You have the right to challenge all relevant laws in this trial in terms of their intent, interpretation, fairness, enforcement, and whether they serve and protect the people of your state. You have the right to personal liberty under the 13th Amendment. You have the right to challenge the jurisdiction of this court. You have the right to argument of recourse and remedy, under UCC 103 and UCC 1-203. You have the right to demand that the code be construed in harmony with the common law, you have the right to require translation of any citation of law or procedure into plain English. As you can see, there are a lot of details and procedure to learn. So if you are not planning to take on this level of preparation, or if you simply want to minimize your exposure to the court system, then we would suggest using the strategy mentioned herein that stands on the Sixth Amendment and backs the judge into a corner. And for whatever portions of this guide you find useful, you would do well to learn those areas of choice, frontwards and backwards, so that you cannot be outmaneuvered. Here are a few general psychological tips. 1. You are Mr. Nice Guy, always polite, diplomatic, and courteous. If you lose your temper or clean language, you lose the case. You are a very smart sheep going into wolf territory. 2. You can say anything you want in court, under the First Amendment. But the more you say, the more you risk. Better to ask questions, and whenever a judge hears something from you that blatantly challenges or threatens her position as a judge, you risk the contempt of court charge. 3. The judge and prosecutor are working together against you. You will see how they cover each other's butt. The judge is supposed to be just a referee. Sometimes you can catch the prosecutor coaching the judge along and trying to control the judge's answers. 4. Whenever the judge or prosecutor is overly polite to you, it means that they want something from you very much. Beware. They are probably wanting you to agree to or say something that gives away more of your rights. A dead giveaway is when the prosecutor proposes a motion and speaks very fast so that you cannot understand. 5. The judge will always try to make you believe that you only have the options that she is presenting to you. Do not trust for 1 millisecond that the judge is telling the truth or quoting the real law. You know better. 6. The judge and prosecutor both know that, although the hearings are taped, only the transcribed written record is admissible as evidence in a later hearing. You can suspect they will try to get you to believe something or communicate some lie or manipulation that will not appear on the written transcript. Oh, they are just so clever. 7. The judge is conditioned to hear grossly distorted versions of reality, from opposing viewpoints from the attorney's liars, who in turn expect the judge to rule in their favor, by making the other attorney appear to be a bigger liar. 8. Exaggerations, false premises, and false conclusions are the primary tools of the prosecutor. And they will both interrupt you while you are talking. Learn to object immediately and limit their abuse. 9. If the judge determines you to be a fighting loudmouth patriot radical, with a bone to pick, she will probably make things more difficult for you. You will not be allowed to make very many, if any, constitutional claims or arguments. 10. Know the psychology. If you let the prosecutor walk all over you, the judge will assume that you don't know very much. They will both take advantage of any weakness you show. 11. The judge will be watching and listening to you, to see how much you know about your rights and the law. This tells him/her just how much they can get away with in court. The less they think you know, the more they will let their guard down, and the more fraud they will attempt to perpetuate. 12. The judge and prosecutor are very slick in their technique. They will both be playing according to what they think you know. If you impress them as being very knowledgeable as your own defense counsel, they will tend to be very careful not to expose themselves on the record. They've been pulling this stuff off for over 150 years, in their refined and corrupted system. 13. The judge and prosecutor must, by definition, violate the law in order to win the game. They do it all the time, and they are good at it, but they seldom run up against people with your knowledge of the truth. And there is always a way to expose the violations, as they happen. The trick is to do so without being charged with contempt of court, heavy fine dollar. You will be sliding them into it. 14. The judge is very good at avoiding questions when you put him/her on the spot. So you must be even better at steering the judge with your questions into a corner. 15. The judge will try to convince you that you are in some regional court of statutory jurisdiction, or other such nonsense. This is entirely false. In this case, the court is operating under color of law, i.e. phony, because it is using another name for its obvious admiralty military jurisdiction. Just look at the gold fringe on the flag. It is also fraudulent because it is operating outside of its geographical venue, defined as the 10 miles square region of the District of Columbia. The only 3 legal jurisdictions allowed by the Constitution are summarized below with their respective basic properties. Common equity admiralty. Type of penalties: criminal, civil, civil, criminal. Basis of law: God, Constitution, contract, international contract. Compliance with law: life, liberty, pursuit. Compelled performance: compelled performance. Required proof of crime: injured party, violated contract, violated international contract. Colorable means phony, bogus, and not genuine. Chances are, if your court hasn't yet converted over to Article 3 common law yet, as per sealed executive orders from the U.S. Attorney General, then it is fraudulently operating as a statutory court of commerce with international jurisdiction. By holding the court to a legal jurisdiction, you will automatically expose their fraud. Winning the game. You win the game by getting a judge or jury, if it gets that far, to dismiss or throw the case out. There is enough truth and strategy herein to hang them with your first appearance. But based on your level of skill, preparation, and/or your personal goals, you may need to go all the way to appeal, in order to win. Some masochistic patriots are eating this stuff up just to get the full courtroom experience. Alternately, if you are the prosecutor going after some public official, you win the game by getting the judge or jury to find the accused guilty as charged. This is much harder, and this is why there are Title 42 classes available, so that the people can learn the procedure that the courts do not want anyone else to know about. Thirdly, for a traffic or tax case against you, the judge and prosecutor wins by the judge or jury ruling that you have indeed done something wrong, i.e. guilty as charged. Defensive techniques. Once you have decided how to proceed with your strategy, you will be faced with having to adapt and make adjustments as you go, in order to make your plan succeed. How you use your knowledge, perceptions, and skills against the tyranny imposed by the judge and prosecutor will determine whether you win or lose. And there are as many adaptations for you as there are judges, because of psychology. It will inevitably be a psychological contest between you and the judge. But as long as you can perceive what the judge's game plan is from a psychological viewpoint, you will have the upper hand, because the judge's game depends on your ignorance. Fortunately, the judge can only use a few basic strategies because of the laws of court procedure and his/her duty to follow them. The prosecutor's strategy can only follow one basic plan: you are guilty, you did this or that, this clearly violates the code, you are guilty, rewind, playback, rewind, playback, etc., etc., ad nauseum. So here are a few more general factors and guidelines in preparation for playing your winning strategy. 1. Make sure that you are in a court of record, before you say anything else. Just ask the judge if the recorder is on. This will put them on notice that you mean business and you will not be hoodwinked. 2. If they ask you if you understand, say no. This is a surefire way to control the case, and to employ the best strategy described herein. If you answer yes, you are giving up your Sixth Amendment liberties. So just say no, and use this opportunity to embarrass the judge into admitting more of the truth, the law, or the judicial decisions relating to your lack of understanding. 3. Admit nothing. Ask questions. Every question you answer in court digs you deeper and deeper into the jurisdiction hole. Your answers automatically give your implied consent to the court's jurisdiction and authority over you. And everything you say is already being used against you. They are trained, just like the officer, to get you to admit things that incriminate you. So, it is in your favor to admit nothing, and keep asking questions. This way you will control where the discussion and evidence is going. 4. Act dumb, play smart. From the above game rules, you can easily see that it is to your advantage to lull the judge into a comfortable position, so that she will more likely expose or admit some mistake on the record. So one of the most powerful ways for you to play is to act dumb at first, and then quietly go for the throat when they